Anyway, since we seem to be out of witnesses, I thought I'd drink a little.
So are we recording now?
We are on.
Okay, well, yeah, there it says right there, they're recording. Here we are, Straight Law Cocktail Podcast in the same room.
This is the first time that we've done this in the same room together.
And we both happen to be in the office. And so we thought, yeah, we'll try this out. And we're also trying out Tyler's new fancy microphone that has a light, which I'm going to mute for a second so you can see it. We're unmuted again. So Tyler, how's your week? You had JDR this morning?
Yeah, I had a binding JDR this morning. And
Binding JDR.
A binding JDR. Whatever that is.
So we're not going to get into it because it's still ongoing. And
right.
I don't want to prejudice your client or yourself by giving my thoughts, so we won't. Best of luck in the conclusion of that.
Yeah, it's great.
I was in court briefly on Zoom this morning, adjourned my application. And so Tyler's JDR is done, and I'm casual because I'm not in court this afternoon. So we thought we'd do the Straight Law Cocktail
Today, which is
Thursday.
Yeah.
And what are you drinking here?
I've just got some bourbon. The Woodford Reserve.
And I'm drinking Ouzo.
Oh, just Ouzo.
Just straight Ouzo.
Well, on the rocks. All right.
Because I wish I was in Greece. My favorite place on the earth that I can't go because of COVID. So screw COVID, but I'm going to drink some Ouzo anyway.
Drink some Ouzo and hang out with me.
There you go. It's almost like being in a Greek island. Not quite.
So I'm sorry that we were absent. We weren't around for a couple of weeks. I had, like a little child, I had my tonsils removed. And I actually got to stay in the pediatrics ward for a night for some reason. Yeah, it was appropriate. And so I've been struggling to recuperate and recover, but I'm pretty good. I still got some stitches down my throat, but I'm feeling way better now.
So I've been holding down the fort, sort of.
Oh, great. You're doing great. Yeah.
And we're approaching the end of the week, and it's been busy, our little office. And we've managed to be busy without getting a lot of advertising on CTV or the Globe and Mail, like Schulman and Partners. If you follow my Twitter at all, a whole pile of newspaper articles masquerading, that are masqueraded advertising for a law firm, which I found amusing. Somehow we don't get newspaper articles, but we still manage to be busy. So I think what we're going to talk about today was a interesting decision called Climans and Latner from the Ontario Court of Appeal, just released, I think, in the last couple of weeks, where they basically found that a couple who never lived in the same home on a continuous basis, they shared weekends together.
Every second weekend for some time.
They went on holidays together.
And he had some like vacation properties where they would live together for a couple months at a time. In the summer, they'd holiday there.
Yeah. He had offered her a marriage on a condition that she sign a cohabitation or a prenuptial agreement, which she consistently refused to sign. And he thought, based on probably pretty good legal advice, that he was safe.
You're not living with her. You're not going to end up paying spousal support, alimony. Probably be okay. That's pretty good advice.
Yeah, and I've given that advice.
But what happened to this guy?
Well, this guy...
He wasn't your client, was he?
No, fortunately for me.
Yeah.
Or maybe him, I don't know. But the Ontario Court of Appeal said you don't have to actually live together. If you're in a committed relationship, that apparently strongly committed boyfriends and girlfriends are enough to entitle you to, in this case, I think it was like $53,000 a month alimony, spousal support.
Okay, now in all fairness, you don't end up having to pay $53,000 a month in spousal support unless you got a ton of money.
Yeah.
And so you can kind of get the gist, the idea here that we got a guy who's got a ton of money who dated a woman who became accustomed to spending that money.
Yeah.
And now she gets to continue getting that money, even though the relationship's over.
Yeah. And I think my comment on Twitter, I mentioned this case, and my Twitter comment succinctly was, you can't make this shit up. This is reality. This is the reality of family law, where there is no known law. There is the law as we understand it today, which isn't necessarily the laws it will be tomorrow.
No, I've given that advice before, where I tell clients, here's a prenup, here's a cohab agreement. This is the best protection you're going to get today based on the case law that exists and the legislation that exists today, and even sometimes legislation or case law that we might anticipate is coming down the line. But this threw a wrench into things, for sure.
Yeah, it is what I would refer to. We talked about this earlier. When I was in law school a million years ago, mid-'80s, our professors spoke with high degree of criticism of the concept of palm tree justice. And Tyler, I think when I first mentioned that term, you didn't have any idea what that meant.
No.
And so I explained to him that palm tree justice is premised on the idea that in more traditional cultures, when people had a dispute, they would sit under a palm tree with the elder or the leader of their community, and they would share their story, and he would make a decision. And that decision was based on whatever he thought was fair, and there was no stare decisis, is a Latin term we use. There was no precedent. There was no predictability. It was based on his whims at the moment of what was fair and unfair. And at least back in the mid-'80s, the professors I had from the University of British Columbia said, this is a really terrible thing because it doesn't allow people to organize their lives in accordance with a somewhat structured statement of their obligations to each other so that they could form reasonably predictable legal entanglements, understanding what the consequences were.
So what Rob, because that made very little sense to me. What Rob means is we want the law to be predictable. We want to know that if we run someone over with our car and we don't have insurance, we're going to get sued and it's going to be out of our pocket. We wanted some predictability in the law. And this palm tree justice, it's kind of this gut instinct stuff. It's tough to know. What's the predictability, right? And so we want that. We also, we want to balance the predictability with sort of this flexibility to apply the law to new circumstances and new scenarios, which is sort of what happened in this case.
Well, it happened in spades.
Right.
This gentleman clearly was advised by his lawyers not to live with her until she signs a cohabitation or a prenuptial agreement.
That's evident, yeah.
And he did that, and she knew that, and would have been aware that his intention was they were not creating a legal relationship relative to legal obligations.
She refused to sign it, right? She knew he wanted it. She knew they weren't going to live together unless she signed it. She refused to sign it. They still didn't live together.
So then what happens is it sounds like the girlfriend had a falling out of some type with the adult daughter of the gentleman, her boyfriend, Mr. Latner, and they broke up. And the unfortunate situation was that for all her wonderful qualities, apparently she had a complete incapacity of earning anything approaching minimum wage. She was limited to $21,000 a year as a yoga instructor. And he was a multimillionaire and clearly I mean, when we beat around the bush, the court went, well, it seems really shitty that you have a whole bunch of money and she doesn't, and so we're going to give her a bunch of your money. I think that's really what the decision says. But the problem is, when clients now come to me and they say, well, I got this girlfriend and we're dating and she wants to move in, I used to say, well, sign a prenuptial agreement. And if you don't do that, don't let her move in and you'll be safe. And now I have to say, does she make as much money as you do? And if she doesn't, what do we tell her?
Yeah, you really shouldn't date that person.
Yeah, you
Better
tell
off
him,
dating somebody who's got the same amount of money.
kick her to the curb, right?
Okay, now in all fairness,
You
Rob,
gotta go, sweetheart.
there's a little more at play here, okay? So there's a little more at play in this case where Mr. Latner seemed to enjoy having this woman and her schedule at his disposal. He enjoyed having her be able to cook meals and bring it to her house when he wanted.
Because the law was that he wasn't at jeopardy. And he bought her all sorts of shit, and the court goes on to say,
I don't want you to work. I want you to be available for my schedule. I want you to go to summer with me. I want you to be able to go on holidays when I want to go. I'll take care of some bills for you if you don't work. So the lines got blurred a little bit there. So I suppose if a client came in and said, I got this girlfriend or boyfriend, and they don't make as much money as me.
But wait a minute. Let's be candid.
Okay, fine. Yeah, all right. Typically,
do you believe were the tables turned and it was an incredibly rich woman with a gentleman that was a yoga instructor that he'd be getting alimony?
In my experience, you would have had a judge tell, if the tables were turned, they would tell the gentleman, why don't you go get a job?
Exactly.
That's my experience anyway.
But getting back to my point though, whether or not the lines were somewhat blurred because of holidays or whatever, or her supporting him in ways other than financially, the question is, if a person, let's be direct, if a male person, has a significant income and is dating a woman with marginal or modest income, and he says to you, what should I do? I'm a little bit nervous because I'm making a pile of dough and my girlfriend doesn't. What do you tell him?
Yeah, it's not, gotta kick him to the curb. Yeah, that's
the easiest thing to do.
That's the best protection you're gonna get.
The only protection is don't spend weekends with each other. Climans and Latner says there is a very gray line that dating may be enough to require you to pay someone $53,000
particularly if there's a big income differential.
Yeah.
Now, more advice you could give beyond that, if you insist on dating somebody with way less money than you could say, make sure you're spending equal amounts on anything you do together, whether it be vacations, properties you buy, anything. Now that might not be very feasible or possible, especially if there's a big income differential, and that might drive you again.
Yeah, but you don't even know if that's going to protect you.
No,
because
you
of
don't.
course, it didn't rest its decision on
No, it didn't.
what her contribution was. In fact, the court said she contributed relatively nothing to his success.
Yeah.
So whether or not she contributed to the cost of holidays, or they had, because in this case they had a clearly separate financial arrangement.
True. Yeah.
They didn't bank together.
Yeah.
So
they had their own assets.
So you got this decision that, frankly, I think is stupid in the extreme. I imagine it's going to find its way to the Supreme Court of Canada. If history tells us anything, the Supreme Court of Canada will probably uphold it.
Probably.
So palm tree justice runs amok again, which means lawyers get to argue more stupid shit for lots of money. Because everything is arguable. There's very little anymore where you can say with any certainty, this is not worth arguing about.
Yeah.
Do you get that sense in family law?
Yeah, I mean, let's say I get a woman comes in that fits this profile. All right, let's run it. Sure, let's give it a shot.
Let's take it a shot.
I can make some money. You stand to benefit. We could give it a shot. Now, we're here in Alberta, and this is an Ontario Court of Appeal case.
True.
Do you want to tell us about that, Rob, or do you want me to talk about it?
Well, in my experience, the level of deference the courts have in Alberta for what judges do, in particular in Ontario and British Columbia, is modest for various reasons. Some of it is, I think, professional ego. We know better. Some of it is our social realities are slightly different, and the court is a reflection of its community on some level. So unless this goes to the Supreme Court of Canada, will the Alberta courts follow this? I suspect some will, for certainty. And then ultimately it'll find its way to the Court of Appeal, and they may or may not find favor with the approach taken by the Ontario Court of Appeal. The thing I found really interesting in this case, the legislation in Ontario is fairly similar to our legislation in Alberta, where to entitle you to support, you have to be, in the wording in the Ontario, which is very similar to Alberta, you have to have cohabited continuously for a period of not less than 3 years. And continuously seems to be the operative word that really forms the argument in this case. The curious thing is, as you read this case from, again, the Ontario Court of Appeal, and it's, how many pages is it?
Oh, I don't know how many it would be.
Anyway, several pages
of
decision. It's probably 10 or 15 pages. The word continuously is used twice. So the central issue in this case, whether or not these people cohabited continuously, it's referenced once when they cite the statute, and once when they sort of go, you don't have to actually live continuously to live continuously.
Now I wonder, is that the court's fault? Or do you think that to some degree Mr. Latner's lawyer should have pushed that issue a little bit more? And I guess, we see the written decision. We don't see what the argument was. We don't have the transcripts from the hearing. But I do wonder, that to me seems like a big issue. You have to have lived continuously, cohabited continuously for at least 3 years. And the facts of this are, they spent some weekends together, every second weekend for a period of time, and then some summers together. That seems like a big issue. And I wonder if that was just on the court, or if there was some issue about.
I'm thinking, this gentleman's paying $53,000 a month alimony. I'm thinking he paid some pretty good lawyers.
Oh yeah, fair enough.
So I'd be shocked if they didn't say continuously about 1 million times during the trial. It's hard to say, we don't have a transcript of what happened. Yeah. But it was rather shocking to me, and I think the decisions, personally, I think it's poorly decided. But the fact that the court was so, it was so easy for them to ignore that issue, that term. They really spent a lot of time talking about conjugal relationships and cohabitation being a broader definition than continuously sharing the same residence. But continuous means something. It's not a term of art. If nothing else, one would think, right? If you said to me, I continuously held up this glass of ouzo throughout the podcast. Now, I think a normal person
would say that strictly is not the case.
I think, but the thing is, I think they would say, well, maybe if you put it down for a minute and you pick it up again, as long as the vast majority of time you were holding that ouzo up, you might be able to say you continuously held it up. But is there a single person out there, just feel free to write in, to comment, is there a single human being in the known universe that would say, if I do not hold this up at least half the time of this podcast, I could still say I held it up continuously? What do you think?
What if you only held it up every second weekend?
Yeah. 2 out of 14s, right?
Yeah, I would say
So the
not.
point is, if you can't at least get to 50-50, I think common sense
It's got
suggests you're not continuously doing anything.
Yeah.
And apparently in Ontario, at least at the level of the Court of Appeal, continuously can mean something less than half, which seems odd to me. But, I'm an old guy that, maybe has a hard time changing with the times.
So the predictability that you and I want out of the court system is unfortunately questionable, especially in light of this case.
Yeah.
And you know what? The thing we haven't touched on is what sort of message does that send to the public at large? So we did touch on this a little bit recently. What do you tell your client who's going to date somebody who makes significantly less money than them? What does that mean when their lawyer has to tell them, law, that you're running a pretty big risk?
Yeah.
You probably shouldn't do it. That's not a good message to say that these single moms, these people who are underpaid for their contributions are not dateable or not dateable by somebody with a large income differential.
And that's an
not what we
interesting
want.
point, because I did read some time ago an article that talked about class stratification in North America. And one of the things they said is the increased aggression of the courts in awarding alimony and division of property has resulted in an increased stratification, so that people of means are less likely to date outside their class and outside their economic sort of peers.
And think about what that means generationally a little bit too, right? I do fine. My son will get educated. My daughter will get educated. They'll hopefully do fine. They're not going to date people who make less money than them. And all of a sudden, we've got all the top end getting higher and the lower end getting lower. That's what this class stratification means. And over time, that's scary. Well, right now it's scary. Give it a generation or 2 or 3, it's scarier and scarier. It's not what you want.
Yeah.
Well, no, I don't think it's what we want.
Yeah, and you're exactly right.
Yeah.
I mean, you have a couple of things going on. You have increased potential class stratification. You also have a diminished respect for the courts.
Yeah.
Because I think what happens is we exist sometimes in our little echo chambers, and if I am, you look at the U.S. election. If I'm on Twitter and I'm a Trump supporter, I like talking to everybody that shares that opinion. And if I really like Joe Biden, I like talking to people with that opinion. And no one ever challenges you to go, you're out of your freaking mind if you like Donald Trump, which would probably be the prevailing wisdom. But regardless, I think sometimes in the legal profession, and certainly maybe at the judicial level, we exist in a little bit of a thought bubble, and you make decisions that you try to respond to what you perceive as a hard case, if you will, but it stretches credulity in a way that you wouldn't do if you were sitting at a bar talking to your friends.
Right? Who might hold you accountable?
So while we were just doing this discussion, I thought maybe I'm out of line, right? Maybe continuously doesn't mean at least half. I thought it did, but I could be wrong. So I just quickly looked up definition of continuously, Merriam-Webster, in a continuous manner without interruption. That's Merriam-Webster. What else? Dictionary.com. I mean, what do they say? Adjective, uninterrupted in time without cessation. Oh, okay. What about the Cambridge Dictionary? Continuously without a pause or interruption. So I think when judges say continuously means a lot of the time, most people in public are going to think that judge got his head up his ass. It's my opinion. But there it is.
I feel a little better criticizing judges in Ontario. Yeah, it's not right.
That's problematic.
It's problematic.
And again, being a judge is hard. I've sat on hearings for law societies, in a judicial capacity, and it's a difficult job. But I think at some point, there has to be some semblance of understanding on the part of the judiciary to respond to what seems to be pretty clear legislation in a manner that would be understood by the public. So if you got a couple of lawyers, I've been doing this for 35 years roughly, if it doesn't seem to make sense to me, the idea of the man on the street, that making sense, and them feeling like this is a reasonable approach, it's just not going to happen, and that erodes respect for the rule of law, which is pretty fundamental to our democracy
and society generally.
So,
which we've talked about in other episodes. Yeah.
So, and maybe I've been a little bit harsh. Maybe it's the ouzo talking. Maybe it's the COVID making me bitchy and grumpy. All of that's probably true. But I still think it's a terrible decision. And I hope the Supreme Court of Canada overturns it. I guess we'll find out. And I hope Alberta judges don't accept it. But I think some of them will, and then I'll get to a Court of Appeal. And I guess we'll see what the Court of Appeal does with that in Alberta.
Then we'll just be players, and we'll give you the advice that we got to give you.
Yeah.
That's it.
That's it.
All right, everybody. Well, this is Thursday for us, but we're not going to see you on the weekend, so have a good weekend, everybody.
Enjoy your COVID if you're in Quebec. Keep your eyes open for those apparently easily obtained warrants where police are going to kick down your doors to see if you're having a beer with your brother-in-law.
Heard about that.
And be safe, be healthy. See y'all later.
Cheers, everybody.